You've been told your whole life that you have freedom of speech. It's the First Amendment, the very first thing the Bill of Rights protects. But here's a question almost no one stops to ask. Does that freedom follow you everywhere? Does a 13-year-old girl still have it when she walks into a classroom? In 1965, a handful of students in Iowa decided to find out. They didn't give a speech. They didn't shout. They wore a thin strip of black cloth around their arms, and it ended up in front of the Supreme Court of the United States. This is the story of Tinker versus Des Moines, the case that decided whether young people keep their constitutional rights when they step through the schoolhouse door, and produced one of the most quoted lines in all of American law. One note before we begin. This is legal history and education, not legal advice. To understand it, you have to feel the moment. It's December 1965. The war in Vietnam is escalating, and it is tearing the country in half. Every night, the fighting is on the news. In Des Moines, Iowa, there's a family named the Tinkers, parents deeply involved in peace and civil rights activism, children raised to believe that speaking up is a duty, not a risk. That month, a group of adults and students gathered at the home of a family named Eckhart. They wanted to do something quiet and dignified, to mourn the dead on both sides of the war, and to support a proposed holiday truce. They settled on a simple gesture. For the season, they would wear black armbands, a symbol of grief, a wish for peace, nothing more. Think about how small that is. Not a march, not a walkout, not a single word spoken out loud. Just a band of black cloth, a few inches wide, worn on the sleeve, and yet everyone understood exactly what it meant. That is the strange power of a symbol. It can say something without making a sound. The law even has a name for it: symbolic speech. And whether the First Amendment protects it was about to be tested by teenagers. But the plan didn't stay secret. The principals of the Des Moines schools heard about it in advance. And on December 14th, before a single armband appeared, they moved to stop it. They adopted a new rule aimed at exactly one thing. Any student who wore an armband to school would be told to remove it, refuse, and you would be suspended until you came back without it. The ban was in place before the protest had even begun. The students knew about the rule. They wore the armbands anyway. On December 16th, 13-year-old Mary Beth Tinker slipped one over her sleeve at her junior high school. So did 16-year-old Christopher Eckhart at his high school. John Tinker, Mary Beth's 15-year-old brother, wore his the next day. They were, by every account, calm and quiet about it. They simply refused to take the cloth off, and so they were sent home, suspended, not for fighting, not for disrupting a class, but for a strip of fabric on their arms. They stayed out of school through the rest of the planned protest until after the new year. Their parents, watching their children punished for a silent gesture, decided this was worth a fight. They went to court, and here's the detail that would come back to haunt the school. It wasn't as if Des Moines had banned all political symbols. Students were still allowed to wear campaign buttons. Some even wore the Iron Cross, a symbol tied to Nazi Germany. None of that was forbidden. Only one symbol was singled out and banned: the black armband against the war. The school had not outlawed disruption. It had outlawed a particular opinion. And what actually happened when the armbands appeared? Almost nothing. Out of some 18,000 students in the district, only a handful wore them. A few classmates made hostile remarks in the hallway, but there were no threats, no fights, no disruption of any class on school grounds. The school's rule wasn't built on chaos that had happened. It was built on the fear of what might. The families, backed by the American Civil Liberties Union, sued the school district. Their argument was simple. Punishing a silent, peaceful expression of opinion violated the First Amendment. The school's argument was just as simple. Running a school means keeping order, and officials have to be able to head off trouble before it starts. Both sides had a point. That is what made the case hard. And at first, the school kept winning. A federal district court in Iowa threw the case out, ruling that the armband ban was a reasonable way to prevent a disturbance. The students appealed to the Court of Appeals, and there the judges split evenly, right down the middle, which let the lower decision stand. Twice now, the courts had sided with the school. The students had one move left. They asked the Supreme Court to hear the case, and the court agreed, because the question underneath this small dispute was anything but small. Do the protections in the Bill of Rights apply to students inside a public school? Or does a school, by its very nature, get to set its own rules? A place where the ordinary Constitution is quietly paused so that education can happen. No court had ever squarely answered it. A strip of black cloth had forced the issue. The case was argued in November of 1968. On one side, the idea that children are citizens too, with rights the government must respect. On the other, the idea that teachers and principals, not judges, should run their own hallways and classrooms. The justices had to find the line between those two truths, and whatever line they drew would govern every public school in America for generations. In February 1969, the court delivered its answer. By a vote of 7-2, it sided with the students, and Justice Abe Fortas, writing for the majority, put the principle into a sentence that law students still memorize today. Neither students nor teachers, he wrote, shed their constitutional rights to freedom of speech or expression at the Schoolhouse Gate. Read that again, because it is doing a lot of work. The court was saying that the Schoolhouse Gate is not a border where the Constitution stops. A student does not check her rights at the door like a coat, and the armband, that silent strip of cloth, counted. It was, the court said, closely akin to pure speech, exactly the kind of expression the First Amendment exists to protect. But, and this is the part people forget, the court did not say students can do or say anything they please. It drew a careful line, and that line is still used today. It even has a name, the Tinker Standard. A school can restrict student expression, but only if it can reasonably forecast that the speech will cause a substantial disruption of the school's work or collide with the rights of other students. Real, likely disruption, not merely discomfort. And that is exactly why Des Moines lost, because the school could point to no evidence, none, that the armbands had disrupted anything. What it had was a fear, an undifferentiated worry that they might. And that, the court said, is not enough. In a line that still echoes, our Constitution does not permit officials to silence speech out of a mere desire to avoid the discomfort and unpleasantness that always accompany an unpopular viewpoint. Fear of an idea is not a reason to ban it, but two justices strongly disagreed, and their argument deserves to be heard. Justice Hugo Black, ironically one of the court's fiercest lifelong defenders of free speech, wrote a blistering dissent. A school, he argued, exists so children can learn, and the moment a novel symbol appears, attention drifts from the lesson to the protest. Hand students a right to wear what they want and say what they want in class, he warned, and you begin a new revolutionary era of permissiveness. You take control of the school away from the teachers and give it to the students. That tension, order against expression, has never fully gone away. But the majority held, and with it came a principle that reached far beyond one Iowa school district. Students, the court affirmed, are persons under our Constitution, in school as well as out of it. They possess fundamental rights the state must respect, balanced always against the real need of a school to actually function. Not unlimited freedom, not zero freedom, a line. Now that line did not stay fixed. In the decades that followed, the court carved out exceptions. It ruled that schools could punish lewd and vulgar speech at an assembly. It gave schools broad control over school-sponsored newspapers. It let a principal take down a banner that seemed to promote illegal drugs. Each case chipped away at the edges of Tinker. But at its core, the rule from 1969 still stands. It remains the starting point, the leading precedent for what a student is allowed to say. And that is why Tinker is not just history, It is a living test. Nearly every modern fight over student expression runs straight through it. A t-shirt with a political slogan, a walkout over gun laws or climate, a post written at home that ripples back into the classroom. When those disputes reach a court, the judge asks the very same question the justices asked about a black armband in 1969. Would this genuinely, substantially disrupt the school? Or does it just make someone uncomfortable? As for the girl at the center of it, Mary Beth Tinker was 13 when she pinned on that armband and got sent home. She would spend much of the rest of her life traveling the country, talking to young people about their right to speak up. A strip of black cloth, worn by a handful of teenagers in Des Moines, had become the single most important case about the free speech rights of students in America. And step back to see what it really means. We've watched the Constitution show up in a police station, in Miranda, in a prison cell, in Gideon, in a phone booth, in Cats, in a fight over the court's own power, in Marbury, and now, in a school hallway, on the arm of a 13-year-old. The same quiet idea runs through all of them. The Bill of Rights is not an abstraction reserved for adults in courtrooms. It is meant to follow ordinary people into the ordinary places of their lives, even through the Schoolhouse Gate. So the next time a student is told to take something off, or stay quiet, or put the sign away, remember the question the Supreme Court asked in 1969, and still asks today. Not, does this bother someone, but would this genuinely disrupt the work of the school? Because the court decided, in the case of a few teenagers and a band of black cloth, that young people do not leave the Constitution at the door. If that's the kind of thing you want to understand more deeply, consider subscribing. We take one landmark case at a time, and we try to get it right. Thank you for watching. And remember, this video is for education and history. It is not legal advice.